Great. Hello, and welcome to the GRadulting workshop series. At today's workshop, we will address some new guidance on the national interest waiver. It's good news, particularly for STEM students. My name is Debbie Mikikon, and I am the coordinator of services and programs for graduate student legal aid. I use she, her pronouns. And unfortunately, my camera is not working today. So I'm sorry about that, but I'm not the person you really need to see. So let's move on. This workshop is co-sponsored by graduate and undergraduate student legal aid. The undergraduate legal aid attorney is here today. Her name is Cindy Schilling. Hi, Cindy. Just
Hi.
a little bit about legal aid before we move on. Our services are free. Well, they're kind of free. You've already paid for our services because you've paid your student fee. So if you need us, come see us. We provide legal consultations on general matters, legal consultations on immigration matters, advocacy for students who are charged by the university, and notary services. And our services are virtual except for notary services. We do those in person. So before I introduce our speaker, I have a couple of announcements. Automatic closed captioning has been enabled for those who want to read along. And we welcome your questions. So post them in the Q&A. If you see a question that you like or that you think is important that it gets addressed, you can upvote it. Near the end of the workshop, I'll post a link to a survey. We only ask 4 questions, and your feedback really helps us offer high quality workshops. So please take the time to do that. And after the workshop, we will email links to the survey, the slides, and the recording. So let's get started with the topic of the day, the National Interest Waiver. I am pleased to introduce our speaker, Patricia Mikikon. Attorney Minikon is a highly respected immigration attorney and the founder of Minikon Law, and they have offices in Greenbelt, Baltimore, and Rockville. Attorney Minikon makes navigating complex immigration processes easier, and she has successfully represented clients in all areas of immigration law for over 2.5 decades. Wow. She started working with the legal aid offices as a volunteer in 2010. And then we expanded and formalized our relationship in 2016 when we contracted with her to meet on a monthly basis with our international students. She provides immigration consultations. And this service, it's very popular and it has grown over the years. Finally, today's workshop is actually the idea of Attorney Minikon. She contacted us and offered to volunteer and update all of you with some good news about the National Interest Waiver. Clearly, she is a fan of UMD's international students, and we are so fortunate to have her with us today. So please take it away, Attorney Minikon.
Thank you, Debbie. It is a pleasure to be back with the students of UMD. And as you said, I decided to bring this to your attention because the rules were changed recently. And based on all the consultations that I have with students, I realized that this was information students could use. And that's where the idea was born. So today we'll be talking about the National Interest Waivers Program. National Interest Waiver is a way for a foreign-born person to obtain permanent resident status in the United States. The National Interest Waiver Program allows a foreign national to self-sponsor. You do not need an employer. There are other requirements including that you have to be a member of the professions with an advanced degree or a person of exceptional ability. We will discuss what each of those categories entails and what type of proof is required, especially to establish that a person is or has exceptional ability. You find a controlling law and USCIS policy in the policy manual of USCIS, which is volume 6, part F, chapter 5. And I included the link for people who are curious and actually want to read this for themselves. The update was done recently, as I stated before, on January 21st of this year. And that the policy update puts into action a case that was decided back in 2016 called Matter of Danasar. That case changed, it vacated a previous case and changed the law and the rules that apply to national interest waiver applications. So because national interest waivers are available to only 2 categories of persons, we'll talk about the first category, which is that you must possess an advanced degree. An advanced degree has to be above a baccalaureate degree. However, you can have the equivalent of a master's if you have a baccalaureate degree and 5 years of experience. You need to be a member of the profession, and we'll talk about that on the next slides. Also, if you have a foreign degree that you're relying on, you will need to have a foreign degree evaluation to assess the equivalency of your degree to a US degree. The proposed position, even though there's no employer, or even if there is an employer, it must require an advanced degree. You need to meet all of the requirements of the position at the time of filing. So if you're basing your application on possessing an advanced degree and being a member of the professions, then you need to already have that degree on the day you file your application or the day USCIS receives it. Now, I mentioned that national interest waivers allow for self-sponsorship. However, they also can be used in situations where there is an employer. There are some employers, especially government agencies, some universities, and other types of employers that cannot file to sponsor prospective worker. And in those instances, the employee can sponsor him or herself, but the employer can also play a part, which we'll talk about later. So what does being a member of the professions mean? The term profession is defined in the law at 8 U.S. Code section 1101-32. Again, like I said, I put this in case people want to actually go and read it. But the term profession includes, but isn't limited to, architects, engineers, lawyers, physicians, surgeons, teachers in elementary and secondary schools, colleges, academies, or seminaries. Now, what this means is if your profession is listed here, then you don't have to prove it's a profession. However, because this list is not exhaustive, if you belong to a profession, you just have to make the case that it is a profession.
So Patricia, I will just read this question now because it's germane to that slide. The first question was, is political science considered STEM? Do these waivers apply to political scientist students? Okay.
Whether political science is a STEM major would depend on the qualifications. Would depend on the curriculum and whether the school considers it STEM. So the first place to ask this question will be your department. And sometimes ISSS can assist in clarifying whether it's considered a STEM degree. And you can also refer to the STEM list that ICE publishes to see if political science is on that list. It's a pretty long list. So I don't know from memory whether political science is included.
Okay, and then a follow-up, members of professions. Do I have to be a member of a professional society or just being an engineer doing an engineer's job?
You would just need to be an engineer doing an engineer's job because it just lists engineers. You do not need to be a member of a professional association to be an engineer.
Great. And then last on this slide, and Jody, thank you for posting the STEM list from DHS. She posted that in the Q&A section if people want to look at that. And then Patricia, does graduate research assistant qualify as a member of profession?
I suspect it wouldn't, just because it's incident to your status as a student.
Okay, and then finally, should the individual be pursuing the advanced degree in the US, or do individuals with advanced degree from another country can apply as well? I think you said it's the latter, but if you could just confirm that.
Yes, if your advanced degree is a foreign earned degree, you just have to have it evaluated for equivalency to a US degree. So say, for example, if you have a master's that's foreign earned, you would have it evaluated. There are educational evaluation companies, and they would evaluate it to ascertain whether it's the equivalent of a US master's in the field that you've proposed it to be a master's in. Can I continue now?
If you want, I have one more question, but I can hold it if you want to keep going.
Yeah. So another place you find the law surrounding national interest waivers is this case, matter of Danasar, that I mentioned. It instructs USCIS to evaluate whether it is impractical for the petitioner to secure a job offer or obtain labor certification. Meaning it would take too much time. The project the person will be contributing to the US, it's something that's time sensitive, or it wouldn't really matter if this person applied for or had a job offer or obtained labor certification, because whether or not they go through that process, and even if there are US workers, the US would still benefit from the petitioner's contribution. Labor certification is a process whereby an employer who has made an offer to a foreign national has to advertise that job. And if any US workers apply who are qualified, the employer will not obtain certification to hire the foreign worker. So you're basically asking the US to waive that protection for US workers, because the US would still benefit. And like I stated, if the contributions are sufficiently urgent to warrant foregoing the labor certification process, which can take 6 months to 2 years. So the interesting thing about national interest waivers is that there is no form for the waiver. The applicant has to complete a form I-140, which is the employer petition for a foreign employee. You file that petition whether or not you have an employer. So self-petitioners still would complete it as them employing themselves. You complete the employee section of the labor certification application as well, but you do not obtain approval from the Department of Labor. You just complete the I-140, sign it, and send it in. Now that the actual waiver, because those are forms, but the actual waiver has no form. Other immigration waivers have a form, but not the national interest waiver. Now, for your waiver application, you would include a detailed cover letter that addresses the 3 prongs that are required, and we'll talk about those in later slides. You want to also include a table of contents because you will need to send in documentation to prove your qualifications and each of the 3 prongs. You need a table of contents to organize your exhibits. They're called exhibits. And you want to organize it by category of proof. So if you're sending something in for prong 1, you want to say, prong 1, and then put all the information under it and organize your actual documents in to be consistent with your table of contents. Now, the first requirement is that you have an advanced degree. So the type of documents you would send in to prove you have an advanced degree would be a copy of your actual diploma, and then your transcript from the US college or university you attended. You want to get an official transcript that will have a seal, and it'll also, attest to the fact that you did graduate. If it's a foreign degree, you want to send in your degree and your transcript along with any translations, if it's in a language other than English, and the educational evaluation. If you have a baccalaureate degree and 5 years of progressive experience, not just experience in one position, you need to have progressive experience. So you would submit letters from your employers verifying the 5 years, and then you would have to submit evidence of promotions and additional responsibilities over time. It'd be good for the employer letter to also have that information, and then you would be sending in additional information. So say, for example, if you were promoted once or twice over the 5 years, and you received a letter promoting you, you would submit that letter in addition to the employer letter. Now, the other category of persons who are able to apply for national interest waivers are those of exceptional ability. So exceptional ability does not have a precise definition, but it is less than the extraordinary ability standard, but above the types of skills ordinarily encountered. So just the fact that a person, maybe did well in school is not going to suffice to say they're of exceptional ability. There are 3 requirements. You have to have exceptional ability in the sciences, arts, or business. So the area of exceptional ability is limited. It's sciences, arts, or business. And substantial benefit to the national economy, cultural or educational interests, or future welfare of the United States. That is something you have to establish as well. And finally, you have to be working in a field sought by an employer in the United States. If, say, for example, this occupation is not one that is in need in the United States, then you would have a hard time establishing that you qualify for a national interest waiver because you have exceptional ability. The evidentiary standard. So when you're applying for a national interest waiver based on exceptional ability, you have to prove you have exceptional ability, and then you have to prove you qualify for a national interest waiver. So you're proving 2 things. If you're applying based on an advanced degree and being a member of the profession, you would prove the advanced degree. You would prove that you're a member of the profession if you're not on that list that we looked at earlier. And then you would prove that you qualify for the national interest waiver. So the required evidentiary standard, meaning this is what the person deciding your application will look at. they're going to look at the preponderance of the evidence, meaning you have to give more documents. If you think of it as a percentage, you have to give at least 51% more evidence that you possess exceptional ability than, say, evidence against that. The evidence will be considered in its entirety. So every document you send will, one document on its own does not have to prove that you have exceptional ability. All of the documents you send will be considered. So if you send 10 items, all 10 will be considered as to whether each item of the 10 sort of, if it were a puzzle, each item of the 10 would be one piece of the puzzle that when you put it all together shows you have exceptional ability. The quality and caliber of the evidence counts. You can't just send everything you think matters. You have to evaluate it. It has to be quality evidence. So say you do need to send your academic record, but your evidence must include 3 out of 6 categories. So your academic record, employer letters showing 10 years of full-time experience. And that may be a challenge for some, but again, it's only 3 out of 6. License or certification to practice in the profession, salary remuneration that demonstrates exceptional ability. Here, you're looking at what the average salary for the position is, and then comparing it to your salary, or looking at the salary range for the position and looking at the fact that you're making like in the top 10% of the salary range for that position. You want to submit recognition for significant contributions to the field and membership in professional associations that you do not pay for. You have to be invited to. And so that's why I said the quality and caliber. So if you've been recognized for, volunteering, for example, that's not considered a significant contribution in the field. So you wouldn't want to submit something like that. You want to make sure that all of your evidence is what they want. Now, you have to demonstrate eligibility for the classification, whether it's advanced degree and member of the professions or exceptional ability. You have to demonstrate that the waiver is in the national interest. National interest is not defined by statute or regulation. So you can get creative here. You can argue why it's in the national interest. And then you need to document why. So remember that cover letter is where you put your arguments, and documentation is where you put your exhibits in the table of contents. The national interest waiver is again judged by the amount of evidence you send in, but you want to divide and categorize your evidence into 3 categories. The first prong is that your proposed endeavor has both substantial merit and national importance, meaning it'll benefit the entire United States, not just, say, for example, the area that, or the state that you live in, or the town, city that you live in, or you will live in if it's granted. The second prong or second category of evidence is that you are well positioned to advance this proposed endeavor. The third is that it would be beneficial to the United States to waive the job offer and thus the labor certification requirements. So let's talk a little bit more about the first prong, substantial merit and national importance. You need to provide details on the type of work you are proposing to undertake if you are granted permanent resident status on this basis. You don't want to include only job duties or general duties of the specific profession. You want to provide details, a roadmap, and explain it, because the adjudicator may not be a scientist or may not know about the type of work you're doing. You establish that this project has substantial merit for projects in business, entrepreneurship, science, technology, culture, health, or education. Notice that the exceptional ability limits the areas that you can establish exceptional ability in, whereas the national interest waiver is a lot broader. It has many more fields. Now you can establish that your project has merit or your proposed endeavor has merit without it having a quantifiable economic impact. So you don't need to say, prove that it will make $1 million. You want to talk about the prospective benefit and the geographic reach. Even though geographic reach is not controlling, this has to be of national benefit to the US. So geographic reach is considered. And you want to talk about how your proposed endeavor will benefit the US, because that is considered as well when judging whether to grant your application. You need to also demonstrate that your proposed endeavor has the significant potential to broadly enhance the societal welfare, cultural or artistic enrichment, or to contribute to the advancement of a valuable technology or a field of study. And that's where the details, providing details comes in. Prong 2 is that you need to be well positioned to advance the proposed endeavor. The focus here is on the applicant. So you want to talk about your education, your background, the plans you have, any progress you've made towards achieving this endeavor that you're proposing. And then if you're an entrepreneur, and we'll go a little more into detail with that later, but if you're an entrepreneur, you want to show proof of interest from investors or customers, potential customers, or even if you're not an entrepreneur and you want to talk about collaborators, you want to indicate that others are interested in what you're doing, because by demonstrating interest, you're also demonstrating utility to the US or people who live in the US. You also want to talk about past achievements related to your endeavors. So if you've been awarded a patent, for example, or you've been awarded a prize when you came up with this idea, maybe at the university level, you want to send that in. Now, types of the proof that a person who's well-positioned could submit: their degrees, certificates, licenses, patents, trademarks, copyrights, letters from experts describing your past achievements and giving specific examples of how you're well-positioned to advance your proposed idea. Publish articles about you would help, about your achievements or about the current work that you're doing. Documentation, documenting a strong citation history of your work, if it's written work, or excerpts of published articles showing positive discourse around your work or adoption of your work by others. Also, you want to show, if you have it, evidence that your work has influenced the field of endeavor. Plan describing how you intend to continue your proposed work once you are granted permanent residence in the US. If this is a business, you want to provide a detailed business plan, the same that you would when you're giving it to a bank, and any supporting documents. If you have correspondence from prospective or potential employers, clients, customers, investors, you want to send it in. Documentation reflecting feasible plans for financial support. So, and we'll talk a little bit more about that for when we talk about entrepreneurs. You, if you've received investments, you want to show proof of that. If you participated in any sort of startup accelerators or incubators, if you have contracts, agreements, licenses showing the potential impact of your idea, you want to provide that as well. Also, letters from government agencies or quasi-government entities, demonstrating that you're well positioned to advance the endeavor. would be very important. And I do talk about the letters from government agencies. Any awards or grants, or other indication of relevant non-monetary support. So if someone says you can use the lab to research, then you want to say that, especially if it's from federal, state, or local government entities with expertise in economic development, research, development, or job creation. Now, if you have contracts, like I mentioned before, documents showing the technology you invented or contributed to inventing and how others use your technology, because this is showing it benefits the US on the national level. The officer will consider the totality of all the documents you sent in. So it's important to be thorough. The third prong is that it's beneficial to the United States to waive the job offer or the labor certification, which is part of the job offer. So you have to meet the first two prongs. You have to demonstrate you're well positioned to advance the endeavor and that the endeavor has substantial merit and national importance before the adjudicator will even look at whether the job offer should be waived. You're proving for prong 3, you're proving that the factors in favor of granting the waiver outweigh the protections for US workers that are provided during the labor certification process. The adjudicator has to balance the US's interest versus the benefit of the document or the proposed endeavor that you are proposing. So the more information you send, the better it is. Matter of the NASAR lists, factors that the adjudicator should consider when balancing. So that is helpful as a guide. Now, matter of DANASAR provided a new analytical framework for adjudicating these applications, and it also canceled out a previous case, New York State Department of Transportation. Basically, you have to demonstrate that on balance, it's beneficial to the US to waive the job offer. And that is the task in prong 3. Now, the new updated guidance that was published in January indicates that endeavors to advance STEM technologies and research in academic or industry settings are assumed to have substantial merit. So meaning they've met, STEM and academic research endeavors meet prong 1 automatically. And that is good news. So someone with a PhD in a STEM field will automatically be concluded to have met the second prong. It is an especially positive factor. So again, someone with a PhD would be considered to have met the second prong of being well qualified to advance the proposed endeavor. And it does not mean that people who have other qualifications cannot prove the second prong, but for STEM PhD is assumed that they have it. Is easier. Now, when balancing factors in favor of a waiver, which is the third prong, the USCIS will consider these to be positive, strong factors that the person has the STEM degree, particularly a PhD. So again, it helps with prong 3, that the person will be engaged in work furthering a critical or emerging technology or other STEM area important to US competitiveness, and the person is well positioned. So having a PhD in a STEM field now pretty much guarantees that if you have a good proposal, you will be approved. Where the endeavor has the potential to support US national security or enhance U.S. economic competitiveness, or when the petition is supported by letters from interested government agency, they all count as weighty factors in the balancing test. This goes to prong 3. Interested government agency or quasi-government agency letters. The interested government agencies or quasi-government agencies includes federally funded research and development centers. Agency letters can support all 3 prongs. If the agency has expertise in the proposed endeavor, the letter can suffice for prong 1, the national merit and substantial merit and national importance. Also can qualify for prong 2 if the letter addresses the petitioner's qualification and why the person's well suited for the endeavor, and can meet prong 3 if it details a particular urgency or how the U.S. would benefit from the endeavor.
Patricia, I'm just doing
Yes.
a check-in. I have about 5 questions in the queue, so let me know when you
Okay.
want to stop. Do you want to do
All
a
right.
couple now?
No, let me just close up and
Okay.
because I'm about to talk about entrepreneurs, and then I'll start with the questions. Thank you, Cindy.
Sure.
So for entrepreneurs, the adjudicating officers have to consider that entrepreneurs do not follow traditional career paths, and so there's no one single way to start up an entity or to structure an entity. Evidence considered to meet all 3 prongs will be evidence of ownership, role, degrees, investments, incubator, participation, awards, grants, intellectual property, patents, revenue generation, growth in revenue, and job creation. You don't always have to have the revenue generation and growth in revenue, but it is considered. If you have it, if you don't, you just submit a financial plan or business plan that shows how you will. You can also, for entrepreneurs, you can show or submit published materials about the petitioner, yourself, the entrepreneur, and your US-based entity, or both. It has to be a US-based entity that you're proposing if you're an entrepreneur. You can get statements and letters from third parties, relevant government entities, outside investors, established business associations that have knowledge of the research product or services that you've developed or that you're proposing, and or are familiar with your knowledge and skills and familiar with experience that you possess that would advance the proposed endeavor. Evidentiary considerations, when you're sending in letter, it has to be letters that talk about research products, services, and your knowledge and skills. Letters from industry experts should provide a form of peer review comparable to academia, and letters by third parties like investors should discuss the merits of the entrepreneur's business endeavor, business plan, product, or technology. So these are people who are familiar. Either you've sent them your business plan, they've read it, and they need to be able to discuss the merits and be familiar with it. Other metrics will be of equal importance in evaluating an entrepreneur's application now. This is aside from just revenue generation or profitability, cash flow, etc. So make your case to the adjudicator. And petitioners are not required, entrepreneurs who petition are not required to establish that their proposed endeavor is more likely than not to succeed. Cindy, I'm ready.
Great. Okay. First one, is it true that to qualify based on a national interest waiver, you must show that you have made original contributions to your field of work that benefits the U.S. on a national level, and that your advanced skill set makes you uniquely qualified to continue your important work in your field? We must explain specifically your original contributions to your field of work and how they benefit the U.S. In addition, must we show that the advanced skill set makes you uniquely qualified? I don't know if I'm repeating this.
Yeah.
We are finding that we must generally show that your work is already benefiting the U.S. in some way on a national level.
Okay, so the question really centers on prong 1 and prong 2, it sounds like. You don't need to show your work is already benefiting the US, but it depends on the type of proposal. The substantial merit, you don't already have to show that you've already contributed to the field. However, a lot of ideas and a lot of proposals demonstrate that just by proving, sending in some of the proof that I mentioned before. And this person may or may not have asked the question before I discussed the 3 prongs. So I'm not sure, but you don't have to prove it has already benefited. You're showing that the idea will benefit, and you're establishing that you are well positioned based on your qualifications, any skills you might possess beyond your qualifications, and any plans you've already taken, if you have. Again, like I said, the answer to the question sort of requires knowledge of what the proposed endeavor is. And then the balancing of interests. If your proposed endeavor has not benefited the US already, you would establish why it would benefit and why it would be in the US's national interest to waive the job requirement.
Great. All right. If the undergraduate and graduate degrees are STEM, but the advanced doctoral degree is non-STEM, does that qualify?
Well, in that case, no, because there's national interest waiver, which applies to advanced degrees, and the person qualifies because they have an advanced degree. And then there are special rules for STEM grads and for entrepreneurs. So the fact that the person does not have a STEM PhD only means that they will not be assumed to have met prongs 1 and 2. However, they can still establish that they meet prongs 1 and 2.
Okay, great. Jody pointed out that if you're an F1 student, you can see your CIP code listed on your immigration document. If you are not an F1 or J1 student, you would need to ask your department what CIP code your particular major holds. Okay, I have checked, and political science is not considered STEM according to the ICE list. Can I still apply if I'm a member of the profession, for example, assistant professor at Maryland, and prove exceptional ability?
You absolutely can apply. What you just stated is 2 bases to apply. If you have an advanced degree, a PhD in political science, you can apply under the advanced degree requirement. If you possess exceptional ability, you can apply under the exceptional ability prong as well. So you would have 2 options, which one you want to apply under. And then you would just make your case that, the academic work you're going to be doing would benefit the United States on a national level. I will say, though, a lot of teaching positions in and of themselves do not qualify. But if you're going to be teaching and engaging in research that would benefit the US, that would qualify. Because if you're only teaching at one university, it only benefits that university, and so it's not of national importance.
Okay, Kevin asks, was the standard for the first prong recently lowered from national importance to just local importance?
No, the first prong is still substantial merit and national importance. And the proposed endeavor has to benefit the United States on a national level.
Okay. Can a national interest waiver application affect your OPT-based EAD application? And if yes, to what extent?
Well, the answer is it depends. if you file for your OPT EAD and then file for your national interest waiver, you haven't, even though you've put in an application for an immigrant visa, you haven't actually applied for an immigrant visa because it could be denied. And not only that, to apply for an immigrant visa, you have to apply for adjustment of status. So, you know, if you file for your OPT first, and then say you're a STEM major, you file for your first OPT, you file for the national interest waiver, and then you file to renew your OPT. Unless you've already filed for adjustment of status, you have not filed for immigrant status, which would contradict an application based on student non-immigrant status.
Okay. To clarify, does having a STEM PhD degree and working at a US company highly related to my degree automatically pass me through the first two prongs?
Yes and no. It depends on what your proposed endeavor is.
Okay.
So,
Go ahead.
I'm sorry. So if you are working for a company and the company wants to write a letter in support, so you're working for a company and maybe the work you're doing does benefit the United States on a national level. But the fact of possessing a STEM PhD and working for a company does not in and of itself qualify you for the first two prongs. You're qualified for the first two prongs when you have a STEM PhD in relation to the proposed endeavor or the proposed job.
Okay. Does the new STEM edition help PhD holders in the humanities in any way?
Well, humanities is not considered a STEM area. So the rules that apply to STEM PhDs or STEM majors would not apply to a humanities major. But if you have an advanced degree in a humanities major or a humanities major, you can apply for the national interest waiver because you'll be evaluated on the proposed endeavor. The benefit of the STEM PhD is that when it comes to the proposed endeavor, the person is assumed to have met prongs 1 and 2. However, anyone in any major, as you'll see from the slide that I had mentioned before, anyone in any major can apply for the national interest waiver. So, yes.
Okay. Does this take the place of an employer sponsoring an H-1B visa if it is STEM related?
Well, it would depend at what point, because a lot of times the H-1B is filed because there's no other ability, there's no other means for the person to work for the employer. Now, if the person, say, for example, does not have the ability to work while the national interest waiver application is pending, they might still need that H-1B. And because they need to stay in status and be able to work. So, yeah, they, you would still need the H-1B in certain circumstances.
Does the STEM PhD applicant's nationality matter?
Well, the STEM PhD applicant's nationality may matter for a couple of reasons. It may matter because it could delay when the person could get the visa. It could matter if the person's nationality is related to a country that the US considers not to be an adversary. And therefore that person might have to go through a little bit more background evaluation in the end, or background and security checks. It couldn't matter, like we saw under Trump, when certain nationalities couldn't get a green card. So in those respects, but the US, no one nationality is really prevented from applying for a national interest waiver because the focus is on the proposed endeavor and it has to benefit the US substantially. It has to have substantial merit and national importance and benefit the US.
I think you've answered this, but I'm just going to make sure. Is there any potential risk to applying for a national interest waiver while they're holding an F1 visa?
Well, the applying for the national interest waiver in and of itself, even though it is applying to get a green card, is not a green card application. It is applying for approval to get a green card, which is lawful permanent status. So it's step one in a journey, and under some circumstances could be a conflict of interest. For clients in that position, I usually talk with them or students in that position to ascertain where they are with the F1, whether they need to leave the US and apply for a visa abroad, because the DS-160, the application for non-immigrant visa asks if you've ever filed, if anyone has ever filed for you. But the fact is, it is not an application for lawful permanent residence. It's an application for approval that clears the way for you to apply for that.
What about a master's degree in a STEM subject plus 5 years professional experience? Does it count like a STEM PhD?
No, the advanced degree equivalency only goes up to a master's, and it is a baccalaureate plus 5 years experience only.
Okay, I'm going to go quickly. We have about, I think, 10 more. I am a third-year PhD student in a STEM field on an F1 visa. Would I be eligible to apply right away?
Well, you don't have a PhD. You can apply based on your master's if you have one, but you would need to have a STEM PhD in order to benefit from the assumption that you've met prongs 1 and 2.
Is all of this for self-petition? What if I'm employed by a nonprofit that is working on STEM education on a national level?
If you're working for a nonprofit, you can still apply for this, and you would apply, like I said, it applies to self-employment, self-sponsorship, or employer sponsorship. So you could apply and indicate that you do work, and your employer would submit a letter in support of the application explaining the work that the nonprofit does, your qualifications for the position that you occupy, and the national importance of the work that you will be doing, which assists the national importance of the work the nonprofit does.
Does applying via national interest waiver green card after meeting all eligibility criteria have benefits over the normal EB-2 procedure for people from India or China with huge green card backlogs?
No, because the national interest waiver is an EB-2 category. So there would still be a wait. The benefit of the national interest waiver program is that you do not need an employer. And if you do have an employer, the employer does not need to test the labor market through the labor certification program, which substantially saves time because labor certification could take up to 2 years.
Associated with that, what is the cost to apply? What are the major milestones, I guess, of the process? And then timeline.
I'm sorry, Cindy, could you read the beginning of that?
Yeah, the cost for applying, the major milestones in the process, I guess the steps, and then the overall timeline.
Okay, so the fees for the application would be the fee for the I-140 application. And I don't know it off the top of my head, but it's I could try to get it. So if that student maybe wants to follow up, but they can go on the USCIS.gov website and just type in fee or click I-140. And then when you get to that page, it tells you what the fees are. The major milestones really would be filing, and then you would get a decision. There's no more communication after you file by mail. And if the government wants additional information, you will receive a request for evidence.
Are the
And the
exceptional?
time,
Mhm.
yeah, the time fluctuates. It could take anywhere between 8 to 12 months, but it does fluctuate.
What time do you need to be done, Patricia? We're at 12:57 and we have about 7 more questions.
I can do it.
Okay. Are the exceptional ability standards for national interest waivers similar or higher than for O1?
I think they're equivalent, but you don't want to start comparing across visa categories. So the O1 is a non-immigrant visa, and the exceptional ability is part of an immigrant visa application. However, both, envision people of exceptional ability. So it should be similar, but you have to follow the requirements of the exceptional ability program, and you cannot use the requirements of the O1 program.
Can a J1 visa holder that is subject to the 2 years home residence requirements use this waiver?
The national interest waiver only waives the job requirement, or job offer requirement. It cannot waive the 212E homestay requirement. So a J1 could, one, return home and serve out the 2 years and apply for the national interest waiver during that time, or would have to apply for a J1 waiver and then apply for the national interest waiver.
Okay, before DNASR, the government interpreted national importance to require geographical reach. How did the case change how the government interprets national importance? After DNASR, applicants had much better success in proving national importance.
Can you read that question again?
I think they're asking, how did DNASR change how the government interprets national importance? Because before the case, it required geographical reach. Did it change after DNASR?
Well, I guess now with the new policy guidance, geographical reach is still important, but it's one consideration, meaning you could benefit Maryland and the rest of the US, even though, so where you are does not control whether the proposed endeavor will benefit the rest of the United States.
Okay. Debbie is typing an answer to the question of whether the recording and slides will be posted. They will be sent to all of the attendees and available. Okay, if you got a PhD in STEM from the US university, can you apply for a national interest waiver from outside the US, like living and working in the STEM field in the home country outside US for 7 years after graduating? So they got PhD here, then left and lived somewhere else.
Well, it would depend on your proposed endeavor. If you've been gone for 7 years, what is the proposed endeavor? What evidence do you have of it? Can you still obtain letters in support from people here that you worked with? You would have to make your case. But no, you do not have to be in the US to apply. The only exception to that is if you're an entrepreneur, your business has to be US based. But if you're outside the US when you apply, if your application is approved, you would apply for a visa at the US Embassy in your country and do it that way. You would not adjust status.
Last question. If I apply for a national interest waiver under the exceptional ability standard and my application is rejected, can I apply again under the advanced degree category?
You can, yes.
So no limit to, I guess, how many times you can apply. They'll consider each petition individually.
Well, because you were denied, but you can't be approved under two, you could, but you can only get a green card with one approval. So if the person applied for exceptional ability and it was denied, they can then apply under advanced degree. The form, the I-140 form has distinct boxes for advanced degree and exceptional ability. So you would be applying under a different section of the law and under a different basis, which is why it's fine. Yeah.
Okay. And then I lied. There's one last question. Thank you very much, Patricia. How do we connect with you professionally?
The last slide has my contact. So people will receive a copy of it. I'm showing it now, and I guess I'm still sharing. It has my contact, and that's how you can get in touch with me.
Great. All right, Debbie, I'm going to pass it back to you to close up.
All right. Wow, Patricia, your voice held out, thankfully.
Yes.
Thank you for an excellent, excellent workshop. Your knowledge of all of these details is so impressive, and we appreciate you at least scratching the surface and helping people explore this based on their own personal circumstances. So many thanks for volunteering your time today.
You're welcome.
Thank
You're
you,
welcome,
Cindy,
Debbie.
for managing the questions. And a thank you to Jody Heckman Bose from ISSS. I saw you, Jody, in the chat contributing to the Q&A. We always appreciate your support. Finally, thank you to everyone who joined us today on Zoom and on YouTube. Please remember to fill out the survey. It will be posted on our website and sent out with that email with links to the workshop recording as well as the slides. And we've got another workshop on Tuesday for international students. It is on Tuesday, March 8th. 3 staff members from ISSS will discuss life after F1 J1. You won't want to miss that. So you can go to our website or go to TerpLink to get the link to register. So that's it, everyone. Have a wonderful weekend. And as always, let us know how the legal aid team can help you. Bye-bye.
Bye.
All right, Deb, you're good?
We are good. Woo!
All right. And only a couple of minutes over the hour.